Now, there is quite a bit of discussion going on related to the Alien Enemies Act, and we're going to address this Alien Enemies Act. But before we do, we need to address a couple of other issues related to jurisdiction and the enforceability of a judge's order. Now, with respect to jurisdiction, you might be aware of this or you might not be aware of this. But jurisdiction is about power, the power to act or the power over something or a situation. Now, with respect to jurisdiction of the federal courts have jurisdiction over federal officers or federal officials wherever those officials might be found engaged in their official duties. And so it doesn't matter whether they are in a particular space in terms of land or sea or air, they are under the jurisdiction of the United States federal court system. Now, with respect to this issue of when a judge's order becomes enforceable, a judge's order is enforceable at the moment of utterance. And so, if in court and a judge orders someone to do something or to refrain from doing something, this is enforceable even before a person actually receives a written order in their hands. And so, with respect to this enforceability issue, no, there is no waiting period for this enforceability. And so, when the judge issues the order out of the judge's mouth, it is enforceable at that moment. Now we're going to move on to talk about this Alien Enemies Act from the 1700s. Now, back in the 1700s, the late 1700s, there were these Alien and Sedition Acts enacted. We're going to be looking at this one that has recently come up, and it is at 50 USC. It's at the US Code, Chapter 3, and it refers to alien enemies. And there are certain sections to this particular chapter related to restraint, regulation, and removal. And then if you go down, you'll see that there's information related to time allowed to settle affairs and depart. And at number 23, the jurisdiction of United States courts and judges. And at 24, duties of marshals. We're going to look at this first portion of this particular act, and we're going to address a couple of things very quickly so that you can see what's going on with this particular act and what can occur with this particular act and under what circumstances. Please be patient with this because oftentimes you will find in law these run-on sentences, and so this is definitely an example of that. And so at 21, we have restraint, regulation, and removal. It reads, whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the event, all natives, citizens, denizens, or subjects of the hostile nation or government, being of the age of 14 years and upward, who shall be within the United States, and not actually naturalized shall be liable to be apprehended, restrained, secured, and removed as alien enemies. The President is authorized in any such event by his proclamation thereof or other public act to direct the conduct to be observed on the part of the United States toward the aliens who become so liable, the manner and degree of the restraint to which they shall be subject, and in what cases and upon what security their residence shall be permitted, and to provide for the removal of those who, not being permitted to reside within the United States, refuse or neglect to depart therefrom, and to establish any other regulations which are found necessary in the premises and for the public safety. Now let's break this down. I'm going to start off with just telling you the problem right up front. This is an Alien Enemies Act, and it is predicated on a declaration of war. A declaration of war comes from Congress. At the current time, we don't actually, as a nation, have any declared wars going on. Yes, there are military conflicts going on all over the world. However, we don't have right now anything going on that is understood as a declared war. And as a matter of fact, as a country, we've only had a few declared wars. Even though you hear about these conflicts that have the word war at the end of them, they are not always identified as these constitutional declared wars. And so this is the first issue right here, is that this act requires a declaration of war in order to make it effective. It goes on to indicate that this declared war would be between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States. Again, here is a caveat: by any foreign nation or government. And so in addition to having this declared war, this incursion, this invasion would need to be perpetrated, attempted, or threatened by an actual foreign nation or government. Individual people coming from other places. This does not necessarily constitute an act by a foreign nation or government. This is the action of an individual entity. And so that's the other problem that we have right off the top. We have a problem with this lack of a declared war, and then this lack of actual official activity coming from an actual foreign nation or government. One thing I want you to always keep in mind is that law is a science. Law is mathematic. And so with respect to the law, you have to look at equations. And if you have any element missing in the equation, you might not have the outcome that you might be expecting. And so with respect to this equation, there are some elements missing with respect to the equation. Now, this act goes on to indicate again, and the president makes public proclamation of the event that we were just talking about. All natives, citizens, denizens, or subjects of the hostile nation or government that we don't actually have in this case, being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, None of this matters at this point because we don't have a declared war and we don't have an action by an actual foreign nation or government at this point. It goes on to indicate shall be liable to be apprehended, restrained, secured, and removed as alien enemies. And so it's not that these things cannot occur. It's that you have to have these precursors before you get to all of this. And right now, we don't have the precursor. We don't have the foundation in order to get to the rest of this with respect to the removal process. It goes on to indicate the president is authorized in any such event by his proclamation thereof or other public act to direct the conduct to be observed on the part of the United States toward the aliens who become so liable, the manner and degree of the restraint to which they shall be subject. All of this is fine and well. However, again, we are still missing that first part of the equation. And so nothing changes. It doesn't matter how long the run-on sentence happens to be. It's still the same. And in what cases and upon what security their residence shall be permitted, and to provide for the removal of those who, not being permitted to reside within the United States, refuse or neglect to depart therefrom, and to establish any other regulations which are found necessary in the premises and for the public safety. Now, while politics and law are often intermingled, there are distinctions with respect to politics and law. And unfortunately, many people have a very difficult time with separating law and politics. Individuals have a very difficult time with looking at the law on its face when it is in conflict with their personal politics. Individuals can have all sorts of thoughts about the individuals at issue with respect to this particular case. And there might be other cases. But individuals can have all sorts of thoughts and feelings about the situation. But it really comes down to, what does the law say? And when entities are entities that create laws, they need to understand what the law says. When you have individuals who are interpreting laws, they need to understand what the law says. And very important is that when you have individuals who are tasked with executing the law, enforcing the law, they definitely need to understand exactly what the law says. These are the entities that are tasked with upholding the law and making sure that we have a lawful and not a lawless society. It is their responsibility to do the right thing, the fair thing, the just thing, and in many instances, the merciful thing. But that is their responsibility. But first and foremost, all of these entities need to know the law. They need to understand the law. They need to analyze the law. They need to look at these equations and make sure all of the pieces and the moving parts are there, and that they are making decisions based upon the equations, not based upon personal politics, not based upon feelings. And this is from the local level to the state level, to the federal level. It doesn't change based upon level. And people need to be very clear about what type of jurisdiction various entities have in certain situations. So hopefully this has been clarifying. If it hasn't, let me know and I will try to further clarify this particular situation. Remember, knowledge is power. Take care.